All right, good morning, Sacramento. This is Craig Ashton. The show is All Things Legal. I'm joined by Edward Shady. This is a time that you want an experienced Shady attorney giving you some legal direction.
Good morning, Sacramento.
And if you've never joined us, this is where curious personal injury attorneys distill topical events into the legal essence. Ed doesn't like this analogy, but he's from Orange County. I went to Berkeley. So this would be like if Ann Coulter and Bill Maher had a radio love child, went to law school, and came up with some ideas on opposite sides of the fence. Ed, you're not gender specific, but you would be the metaphorical Ann Coulter of the show.
I don't think so. You have lighter hair than I do.
Yeah, right, exactly. All right, so let's give you a breakdown as to what we'll be speaking about for the next hour so you can determine whether or not you want to invest that 60 minutes of your existence in this experience. We're going to be talking about an individual that was walking along the bike trail in Sacramento, I think near Campus Commons golf course. Was hit from behind by a what is allegedly a homeless individual, knocked him down, broke his orbital bone, knocked out his teeth. District Attorney's Office determined not to charge for hit and run. We'll talk about why, and we'll talk about the importance of following the rules on the bike lane. We'll talk about Tiger Woods. The New York Post was salivating about Tiger Woods is not showing up to court, DUI. And, well, guess what? If you enter into a plea deal or you plead guilty, then typically your lawyer can do that for you. Not that big of a deal. We'll talk about what Tiger Woods is doing and why it's never a good idea to take Xanax and Vicodin and then fall asleep behind the wheel. It's just not a good idea. Yeah, Tiger Woods needs some help. And, that guy was the best golfer on the planet by far. And then he ended up having 4 back surgeries. And we know, because we're personal injury attorneys, back surgeries can be some of the most disruptive surgeries on the planet as a result of the fact, especially the low back is the fulcrum point by which we as human beings lift things.
Yeah, I mean, it can be absolutely debilitating. You use your back all the time. You're getting out of bed, you're getting up, you're sitting up, you're walking. It's always in use.
Always in use. So,
always in use.
Yeah, so we'll talk about that within the confines of DUI, plea deals, what he did, talk about back injuries, et cetera, within the universe of the personal injury that we do. And then we're talking about this employee at Google who basically said women are weaker, they're anxious, they're hormonal, they're not well suited for engineering. And he got fired. And then the question becomes whether or not that's protected speech under the First Amendment. We'll definitely address that. There's a clear answer to it. And whether or not he's protected under federal law, which is the National Labor Relations Board Section 7, which allows people to talk about work conditions. So that's going to be a colorable issue regarding employment law and whether or not he was rightfully fired. And then we'll talk about one that's pretty easy. Got an inside banker's fall from grace after whipping out penis at party. He's a Swede, and my brother is an investment banker and says he's hung out with Swedes. And during the summer months, they tend to party a bit because it's sunny like 24 hours a day. And they have these crazy parties, and this may be the aftermath. So we can show you one that may be colorable, one that, clearly that's a violation of the morality clause in his contract.
The swinging Swede.
Yeah, so they have Christmas party shenanigans in the middle of the summer there in Sweden, which is definitely, hey, man, all year round you get yourself into trouble in Sweden, apparently.
Yeah, apparently so. This guy, I've been reading that article. Oh, my God.
How
did he get away with that?
So then we got 2 contract cases. One's colorable and one is clear. The colorable one is a couple. They're partners, a male and female, in San Francisco. Identified that a private street in the Presidio, and I think there's 35 mansions. One of them sold for $16 million. They noticed that there was a tax liability of $14 that was not paid, and the street went up for auction under tax auction, and they bought it for $90,000. And so now the homeowners association goes, wait, we never got notice. And the couple's going, look, we're going to put in meters, maybe charge rent for the street. So that is an issue pertaining to notice, and that's colorable. And then we've got the fiance from hell who stole my dog. So this is in New York, but man asked woman to marry. Woman said, thanks for the ring. Said, I ain't marrying you. Kept the ring, took the dog, took the furniture. And we'll talk about contract law, the specific rules in California that say what the rights and obligations are of who gave the ring, who got the ring, and who called it off, and what happens to that ring. And then contract issues associated with the dog and the furniture. I think that'll be interesting. Hopefully nobody has to live that experience. But again, as we say, that'll help your dining room conversation next time you have a dinner party. And if we get to it, a dentist is charged for treating patients while extremely drunk. That guy drank a whole bottle of vodka, and he got through 7 patients before his staff called 911. So, he was, every time he was giving them nitrous oxide, he was taking a shot of Grey Goose. And
Oh, my God.
So that we got assault and battery, medical malpractice. The guy, that's, just not a good idea.
It reminds me of that movie The Graduate when they start drilling his tooth without any Novocaine. Hey, this doesn't hurt. I'm feeling high. How about you?
All right. Instead of today giving you some Novocaine, you have a choice of gin or vodka martini.
I'm going with the vodka. 2 olives.
Dirty doctor, please.
Yes. Who's this guy? I gotta make a dental appointment. I'm gonna go over there. Kidding.
Yeah, exactly.
For happy hour at the dentist office, there's a discount.
Right, exactly. Between 4 and 7, you basically can get a crown put in for half price.
Some Crown Royal.
Yeah, right, exactly. Ed, you're funny, man. All right, so let's go ahead and break down what happened on the bike trail recently. So this is in the Sacramento Bee, so I'm not basically disclosing names for somebody that isn't in the Bee. And this guy's a stud. His name is Bill Finkbeiner. He has done 7 Western States 100-mile races. That's 100 miles from Squaw Valley to Auburn, on trails. I mean, this is not a flat, around the track for 100 miles. This is a no-joke experience. Takes, over 20 hours, and so they run all the way through the night, going through streams, rivers, etc. And it is, what people don't know is the Sacramento area actually has some of the premier races, running races, endurance races in the world. We have the American River 50, the Western States 100, and this is a premier race, and this guy's done it 17 times. So he's walking on the bike trail, I think near Campus Commons golf course, and so the thing about you need to know about the bike trail, it's super important, is when you're on the bike trail and you're walking, you walk on the left-hand side against traffic. Pretend you're in England. The reason is that you can see the bike coming, and the bike can see you coming. So if the bike's coming at you, you can step off the bike trail. Right, Ed?
No, I mean, there's so many accidents occurring. Having logged thousands of miles on that trail, it's always upsetting to see people violating the rules because it puts your life in danger as well as their own, just because they're not heeding to the rules that are applicable.
And the reason, and it's just about safety, because if you're walking in the same direction that the bike's coming, and you don't see them behind you, a couple things will happen. There may be another bike coming, and you see that, but you don't see the person behind you. And especially if you're walking 2 abreast. A lot of people are having a chat. They're blocking the entire bike trail. So they don't know that they're creating a situation where there could be a head-on collision. And it can be very, very dangerous when you're going around a corner, especially downhill. And 2 people are oblivious to the rules. They're walking with traffic, blocking the bike lane. And then you have to go around it, and boom, next thing you know, you hit somebody head-on. Guess what? Liability is going to be on you, the walker, because you basically are violating the rules of the bike trail. Period. End of story. It has been determined that the reasonable care is you walk against, left. And that's safer for you, and it's safer for the bike. So ultimately what happened in this particular case is the Mr. Finkbeiner ultimately was walking with traffic, with the bike trail traffic, was hit from behind by what turns out to be a homeless individual who fled the scene. He suffered serious injury. So Mr. Finkbeiner suffered super serious injury, a broken orbital bone, lost a bunch of teeth. He seems like a really cool cat. He just kind of took it in stride and said, no hard feelings. The guy left. It was an unfortunate happenstance. I mean, he's not a litigious individual. But the district attorney's office determined not to charge hit-and-run charges from a criminal perspective, and a couple different reasons. One is determine whether or not this is a thoroughfare that's governed by the vehicle code or whether or not it's private property, because it was unclear where exactly it happened. And then the other is that because he was walking with traffic, there was a question as to whether or not
he contributed.
Maybe he contributed and stepped in his way, and then at that point there wasn't really a crime; it was more of a civil cause of action.
Yeah, I mean the code section's vehicle code section 20,002, and if it's strictly property damage, you ding somebody's car, most people don't even realize this. If you hit somebody's dog and you leave, that is actually a hit and run because it involves property. It's property damage. So it's not only a vehicle. It could be a post office box. It could be somebody's bicycle, anything. You have a duty to stop, exchange information, or at least leave a note and give me your information. But once you involve an individual and there's an injury and you leave, it steps up to a felony. So this could have been charged as a felony.
Yeah, as long as your life is not in danger, you got to stop. So, I mean, if somebody's got a gun to your head and saying, look, you better stay here, you probably could leave because you're using reasonable care. But short of that, you got to stay. So if you ever get in an accident, property damage or injury, stay at the scene. Otherwise, you're facing a felony. And that's, I think, good advice. So when we come back, we'll talk about Tiger Woods, his DUI, and talk about the issues pertaining to whether or not he had to show up to court in Florida. We'll do that after the break. Edward Shady is joining me, Craig Ashton, on a show called All Things Legal. All right, we're back. This is Craig Ashton. The show is All Things Legal. I'm joined by my friend, colleague, fellow Ironman finisher, Edward Shady.
Again, good morning, Sacramento. Good to be here.
Yeah, Ed, you bring a sensibility from the Orange Curtain in Orange County that is a slightly different vantage point than I bring, but I think the amalgamation of the two makes for some interesting radio.
That's right. I bring reason to your emotion.
Yeah, right. I second that emotion. So we're talking about the bike trail quickly. It doesn't matter where you are in California. You're in San Francisco, you're in Muir Woods, etc. So if you're on a bike trail, walk to the left, bikes to the right. So bikes would bike like it's a regular road. Walkers are going to walk like they're in England or Scotland, right? So you're going to walk on the opposite side. That's for safety. The pedestrians give the right-of-way to horses. Bikes give the right-of-way to pedestrian and horses. Horses get the right-of-way.
Everybody gives the right-of-way to a
Everybody
horse.
gives the right-of-way to the horse.
Because they're big.
Right, exactly. And, they're spookable, etc. So the idea is that those are the general rules. I just got a brand-new puppy named Lucy. Super cool.
Good-looking dog.
Yeah, really cool standard poodle. I've had greyhounds in the past, and we had a beautiful little Bichon Frise Maltese mix that came to us via Belgium and Paris, and developed a unfortunate autoimmune disorder. And we did everything we could, UC Davis, MRIs, all kinds of stuff, and struggled for 2 years to help our little friend. She passed away, and she passed away young, and only 5 years old. I've never had that experience with a dog before. So my lovely girlfriend Tanya identified this really cool standard poodle who looks a lot like a Bichon Frise, but like giant size, and kind of floppy. It's black with long hair. Looks like a sheepdog. And I had no idea that standard poodles are actually hunting dogs.
Oh, I didn't know that either.
Yeah, they're hunting dogs. So I mean, they're actually really active. It's kind of like they remind me of a greyhound because I've had 6 of those. I mean, they're built like a greyhound, but they're just shaggy. So it's like if the shaggy dog met a greyhound and had a
It's kind of funny because every time you think of a standard poodle, you think of that foo-foo poodle with the shaved body and the puffy head and the puffy tail, and et cetera. But actually, when you let the fur or hair or whatever the condition is of the coat grow out, it's got a nice curly shag to it. And they're good-looking dogs.
Yeah, it's like if Pee Wee Herman met Clint Eastwood, and they look a little bit.
Pee Wee would die.
Yeah, they look like they're not confrontational, but they are really athletic hunting animals and they don't know what they look like when they've got that foofy hair and the fluffy tail and all that stuff. So anyway, right now we got a shaggy dog. So the point is that we walk Lucy, and she's only been on the leash now for a couple times, and I have a little Chihuahua named Gordo. So we walk on the left-hand side. And that's because that's the side you're supposed to walk on. And you got to be really aware of it, especially when you have a dog on a leash, because if there's somebody coming behind you and you're actually on the side of the bike and you're blocking the trail, it can be super dangerous. So we're on the left, and the thing that always gets me is that people who don't understand the rules, they're walking on the right-hand side thinking that they're actually following the rules because that's with traffic. What they don't know is they're walking on the wrong side, but they give you the stink eye. They go, what's wrong with you? I mean, I just had to walk to the other side. You guys don't understand the rules. I mean, so the point is understand the rules because it makes for a much better experience because it's safer. There's no unwritten or unspoken sense of animosity about somebody doesn't know what they're doing.
Well, it's kind of funny because
if you're unaware of the rules and then you're actually making somebody feel uncomfortable who's actually following the rules, it's just not a happy experience.
Well, the problem is it seems counterintuitive because when you're driving, you're always on the right-hand side, so you just assume you're going to walk on the right-hand side, and that's what makes it counterintuitive for most individuals. But when you actually get down to it, the vehicle code is actually common sense codified. And if you're going to be walking, you don't want to be walking on the right side because you don't know who's coming. If it's
from behind you can't see it, especially in the day and age with iPods.
Or what if it's a DUI driver that's swerving back and forth? If you see him coming, at least you got a chance to jump out of the way.
Exactly.
So,
and then people also ride their bikes against traffic, and we have all these clients that ride their bikes and they're riding against traffic because they think it's safer. And then that's against the vehicle code. It's like driving a Ferrari the wrong way down a one-way street. That's the way the vehicle code looks at it. And when you're riding against traffic, then the person is pulling out of the driveway is looking left because that's where traffic is coming. You're coming from the right. They pull out, and that's how accidents usually happen. And then the bicyclist is super injured. Their bike's totaled, and then they find out that they're at fault on top of that. It can be a real shocker. And then they actually owe the property damage of the car that they hit.
Having practiced personal injury law for 25 years, I've yet to see in the case where the bicyclist won in the collision with the car. The heavy automobile always wins the fight.
Yeah, it's just never ends well, and so adding salt to the legal wound is when you're actually injured, you've lost your bike, you're at fault, and then you got to pay for the property damage of the vehicle.
And it's usually gravel to the legal wound.
And the thing that is interesting on these bike trail cases is that many times the at-fault party's homeowner's insurance will cover it. And then if the at-fault insurance, if the at-fault person doesn't have insurance, then many times your uninsured motorist coverage will cover it.
No, because a vehicle has to be involved for an uninsured motorist, but the homeless guys.
Well, yeah. Well, I'm sorry. If you get involved in an accident with a automobile, then
correct. As long as the car's involved, and there's contact, your UM will cover.
Good point of clarification. All right, let's talk about Tiger Woods. So, the only thing I have against Tiger is he went to Stanford. Everything else I like. I went to Cal, so he went to Stanford for I think a year. One of the best golfers of his generation. Ended up having lumbar spine injury problems, had a microdiscectomy, which is the least invasive procedure. That didn't take. He ended up having 4 surgeries. And guess what? That type of surgery is super difficult to recover from fully if you're just basically wanting to maybe go bowling once a week.
Yeah.
But, if you want to be the best golfer on the planet with that leverage point, the fulcrum point, as we as bipedal creatures use to lift things, that's what he's using to swing and torque around his lumbar spine. And he's just not been the same. And so a couple months ago, he was in Florida, and he was under the influence of Xanax and Vicodin, and then fell asleep at his wheel. Fortunately, didn't hit anybody, didn't hurt anybody, but that's driving under the influence of medication. Just because it's prescribed doesn't mean that you are not going to be responsible if you are under the influence of it where you can't operate a vehicle.
Yeah, just because it's your doctor gives it's a legal medication. You can walk into a store, you can buy alcohol, it's legal. Doesn't mean you can get intoxicated, you can't become under the influence and drive around. That's the illegal part. Now, the tricky thing is, I don't know how Florida looks at it, but in the state of California, if you get a DUI the first time and you go to DUI classes, you aren't getting an admonition in there. And if you get another DUI where there's fatality involved, you actually can be charged with second-degree murder because it's a Watson charge. And I don't know how other states look at that. So you've got to be extremely careful, and that's why because vehicles are so large and weigh so much, and when they have an accident, bad things happen. They take it very, very seriously.
Yeah, and the New York Post, because for the show, I like to read The Atlantic, and I like Slate, and I like Newsweek, and
you like The Onion too, don't you?
I like The Economist, but I also for the show a lot of times I'll read the New York Post just because they have these crazy scream out stories, which many of them. Most people won't look at them from a legal perspective, but they do it because it's kind of salacious, and I look at it because it's definitely legal issues underpinning the salacious aspect of the story. And their headline was Tiger Woods doesn't show to court in DUI case. And the point is that one of the reasons people get DUI attorneys in California is that, bottom line is the evidence is pretty strong against you. You got a breathalyzer, they took your blood.
No.
And then the only way that you can attack that is if they pulled you over without probable cause, and therefore all the evidence is thrown out. Or there's a calibration issue with the testing, or that there's a chain of custody issue. In other words, that blood that they said was yours is actually, Joe Blow's, and it's not yours. And then at that point, you could attack it. Hey, that's not my blood.
No, I actually won a case on a calibration issue down in Orange County, so that was kind of fun.
Tell us about it.
Oh, it was years ago. A client of mine gets a DUI, and it's actually a 2-course thing. You actually get prosecuted by the DMV, which is separate and apart from the prosecution by the state. So we pled out to the state because there was no doubt she was under the influence, but the Orange County crime lab was actually calibrating their own equipment, which they can't do under their license. It gets technical. So I did the hearing with the DMV and then brought that up and said, well, it's no longer per se. You have to actually bring in actual evidence to show that she was under the influence. They said, we really don't care. We're the DMV. So we're just going to suspend your license. Asked for a rehearing. They did the same thing. Then I filed a petition for a writ of mandate with the court and the judge. And then they brought down a deputy attorney general to fight against my petition on this matter. They lost. They ended up paying all my attorney's fees. My client was immediately reinstated with their license.
Oh, wow.
Yeah, it was fun.
Well, yeah, that's you are a bit of a tinkerer. I would say that if Leonardo da Vinci became a lawyer, that might be you.
I can't draw as well.
Yeah. All right, so getting back to Tiger Woods. So bottom line is that one of the reasons people get attorneys, and Tim Hotson in our office does DUI and expungement cases because he's got a background from the public defender's office. One of the reasons they get Tim involved is they're guilty. I mean, the evidence, it doesn't matter if you have Perry Mason representing you and you have one of those Perry Mason moments, you're still not going to win. I mean, if you've got blood alcohol of, 0.20 or higher, then at that point, it's going to be hard for you to overcome that when it's 0.08. So the reason they get us involved is that we make all the court appearances, and then a plea agreement is entered into, and then there's going to be a fine. There's going to be some classes. There's probably going to be a interlocking device put in your car you got to blow into. And those are all the things that your lawyer can at least take some of the ignominy out of the situation for you. You don't have to show up to a court. And you just kind of realize your problem, deal with your problem, pay your fine, and move on with your life, hopefully.
Yeah, the metaphorical "this blows" really does become you have to blow this to get going.
So they said, will Tiger take the deal? And his attorney said Tiger would.
Yeah, nice.
So basically what he offered Tiger.
Look at G in there. He's totally laughing.
Tiger would. Tiger would. So he gets 12 months probation. He's required to do DUI classes. And then he's pled guilty to reckless driving. So that's one step below the DUI. And then at that point, if he completes everything and he stays clean during his probation, then he's cool. He can't drink alcohol or take drugs while on probation. The issue for him, and it's going to be an issue, is whether or not he's being prescribed Vicodin. Because if you have a doctor's prescription, then there's going to be an issue as to whether or not, if a doctor's prescribing it as treatment for a malady, whether or not they can keep you from taking that within the confines of that plea deal.
No, I don't think they can keep. They can't keep you. That would be cruel and unusual punishment if they were, withholding pain medication for somebody that just underwent a fusion surgery back in April of last year. So I don't see the court doing that. But at the same time, I could see the court maybe monitoring it. Hey, doc, how many is he going to take? He can only get the prescription filled so often, so we know he's not abusing it.
And one of the interesting things is Florida just passed medicinal marijuana for medical purposes. And so the idea is, okay, so first of all, from a federal perspective, that is a Schedule I drug, marijuana, which says, according to Jeff Sessions, in the Justice Department, I mean, that's worse. It's as bad as heroin. It's worse than cocaine. I think it's worse than ecstasy. And as a matter of fact, ecstasy is being put into a Schedule II now for post-traumatic stress disorder. So the whole thing's changing. But this is Schedule I, so really, technically speaking, even having one joint, I mean, you can spend 6 months in jail. So if it's a federal violation, but in state law, they can prescribe that. And so the interesting thing is that technically speaking, if Tiger Woods gets prescribed marijuana within the confines of his plea deal in the criminal system in Florida, now the law has changed at the state level where he can smoke pot and not be in violation of the criminal statutes in Florida.
Yeah, that is interesting.
But don't go to the Everglades. If that's a federal park, then you have one joint in a federal. You step into Yosemite with marijuana, you're toast.
I was kind of laughing because speaking about marijuana, I guess some guys, I don't know which coast it was off, their boat broke down and couldn't get the boat.
And they probably didn't know what coast it was either.
No, they couldn't get the boat couldn't get the boat started, so they finally called the Coast Guard. The Coast Guard comes out, gives them a tow, gets the boat started, and impounds all their marijuana.
That's right.
Should have started paddling, boys.
All right, so we're going to take a break. We broke down Tiger Woods. We're going to talk about what not to do at a party and the Google issue and the memo and whether or not there's a violation of the First Amendment and why you should not pull out your penis at a party because you're going to get fired. All right, this is Craig Ashton. I'm with Ed Shady. Stay with us. This is All Things Legal. All right, we're back. This is Craig Ashton. The show is All Things Legal. Curious personal injury attorneys distilling topical events into their legal essence. What does that mean? Well, we're curious. We basically are serious attorneys during the day. Law partner Tim Hodson, Chris Price and Tim Hodson just got done with a 2-week trial. Spent about $30,000 on experts making a presentation to 12 of our clients' neighbors. And that's what we do during our work time. And then on our off time, what we try to do for this show, a couple hours a week, is break down stories that you may or may not be familiar with, but give you a slightly different perspective. So, Ed, we were talking about Tiger Woods, and this is Ed Shady. This is when you want a shady attorney giving you some legal direction. And Ed's got a brilliant legal mind, and he was reading the Tiger Woods article, and he said, first of all, he was playing he's the champion of the oldest sport on the planet, which, that's just from a legal perspective.
Yeah, the guy says.
Just to parse that.
Yeah, whether you like Tiger or not, is competitive brilliance, and I agree with that. His dominance of the oldest sport on the planet. That's when I saw that, I just went, who writes this? I didn't see golf on the side of a vase from the Greek antiquity.
Yeah, and I don't think the Aztecs were playing golf either. So,
no.
I mean, they had that hoop game, and then the loser got sacrificed. So
no, the winners got sacrificed, didn't they?
The winner got sacrificed. That's right.
The only game you want to lose.
The winner got sacrificed, and they couldn't use their hands because I was at Chichen Itza. You and I were there.
Yeah.
So the Mayans had a very similar game. And, yeah, I mean, everybody would be watching, and they're on a raised area in this enclosed, and then this hoop is made out of stone, and it's got a circle, and they have a rubber ball, and they can't use their hands. They have to use their feet and their shoulders. And whoever scores, right? And sometimes it can take a few days. Whoever makes it then gets sacrificed.
Yeah. That's why it takes so long, because it's only by accident it goes through the hoop and you get killed.
Yeah, you got the equivalent of Rodney Dangerfield back then. Oh, my arm.
Somebody step on a duck.
Yeah, right. So, and then the other is that you pointed out that they found him with the 2 of his tires blown out.
And body damage to the vehicle.
Yeah, so I mean, that was the probable cause that they had. So, if he would have made it into a parking lot, took out his keys, and then fell asleep, he'd probably be fine because there's no way they could prove that he was operating the vehicle under the influence of Xanax and Vicodin. But the fact that apparently the keys were still in the ignition, it was running, and there was body damage, pretty good evidence that he was operating the vehicle under the influence, even though the car wasn't moving.
Correct.
All right, so let's talk about in the news. We got Google fires an engineer who wrote a memo questioning women in tech. It's basically Google kind of encourages the feedback of its employees to have a better work environment. One of the things that's interesting about Google is that the way you get promoted is based upon how your peers look at you. So you get rated by your peers as to how well you work, and so that's one of the things they factor into whether or not you get promoted is how your peers look at you. So when you write a memo at Google that says women have anxiety, they're not genetically engineered per se from an engineering perspective and a genetic perspective to do the type of work. And that's why there's only 19% of software designers as women. That's what this guy's saying.
Yeah, the guy's saying that lack of a Y chromosome is preventing them to move up. What a knucklehead.
So first of all, you're going to expose your job, and you will never ever have a date with a woman again in the Bay Area. I mean, it's just not going to happen, and you're going to have to move to Qatar, or you have to move to you're going to have to join the Republican Party probably.
What?
Hey, no, sorry, that was just a joke. I mean, bottom line, Ed, you would disagree.
No, it's kind of funny because I read the article and Google has long promoted a culture of openness, and this is what the guy's saying that I was being open, but promoting stereotypes is not necessarily openness. It's probably one might say it's closed-mindedness when you're promoting a stereotype. I mean, what is the guy's a racist? He wants to bring out racist comments. Hey, I'm just trying to be open.
I mean, if you're going to start spouting off stereotypes and generalities like this, like women are anxious, they don't deal with stress very well, have about 25 Harvard studies to back you up. Because if you're just spouting off your gut feeling as your observations as a guy who designs software, first of all, you are probably not the best arbiter of how women act because you've probably only been on 3 dates in your life. And then second of all, I mean, using stereotypes within the confines of defining how genders operate, just never helpful. I mean, it's always going to end bad. Just like wearing blackface to a Christmas party, it's always going to end bad. That because it perpetuates a stereotype. Talking about women and anxiety and all this other stuff, without, if you say, look, okay, fine, I'm neutral on this, but I've done some reading and I've got these studies which suggest these outcomes. So I would ask you to consider these studies, not my opinion because that is neutral, but these studies which suggest these things. Perhaps that may help the working environment here at Google, recognizing that there are certain traits that are clearly delineated as a result of gender differences. I mean, we can all agree that women can have children and men can't. I mean, there are genetic differences, right? But to talk about these stereotypes and anxiety, I mean, dude, that is, first of all, you're going to get fired. The First Amendment doesn't protect you. And you're just not a smart thing to do.
Well, it's kind of like, you remember, I don't know if you ever saw it, Monty Python's The Life of Brian.
Oh, yeah.
And the guy's, but I want to have babies. You can't have babies. You're a man. Well, can we all agree he can have the right to have babies?
So, yeah, this guy basically just spouted off a memo and sent it apparently out to all the employees at Google. And then there's going to be a backlash, and it's going to happen.
Yeah, the chief guy, I think he called it Pichai, said he supported the right of employees to express themselves, but the memo in this instance had gone too far, and I tend to agree with him. What if this guy had started spouting out bigot comments, racist things, or going against one religion against another, or not at all, or atheistic, and it was, not for the work environment or politics.
But here's the thing. This is kind of colorable. Now he says, I'm going to exercise my rights to the full extent of the law. Now, the First Amendment does not protect you in an office environment because the First Amendment is meant to protect you from the government stopping you from saying content-based speech that's not protected. Defamation is not protected. Obscenity is not protected. Fighting words are not protected. Inciting words, in other words, riling somebody up to actually cause violence to somebody else, those are not protected and can be curtailed by the government. But beyond that, you're free. So the state of California cannot step in and say you can't say these things. That would be a violation of his First Amendment rights. However, within the confines of an employer-employee relationship where there's a contract, your rights are significantly curtailed. The only issue that he has is a National Labor Relations Board does allow for discussion of wages and work environment issues. And federal law would apply. The reason that we were able to deal with discrimination was through applying the federal Constitution to the South through the Interstate Commerce Clause. And it just said, because you're engaged in interstate commerce, you as a diner in Alabama, you're getting your turnips from North Carolina, and therefore you're engaged in interstate commerce, and the federal Constitution applies to you, and you cannot discriminate under federal law, and therefore you're in violation of federal law, and that's how we went and applied the anti-discrimination laws.
Turnips, really?
Well, I was just reading this really interesting.
Well, it could have been Coca-Cola from Georgia.
I was just reading a very interesting serial radio presentation on NPR radio about a guy who lives in Alabama, who's a genius, who's got the largest maze in Alabama, and he's an horologist, so he fixes clocks, and he can fix clocks based upon memory. So he would go to a clock that's from the 1800s and then basically deal with some of the movement and then shape it and then put it back together. Doesn't need a plan or paperwork. He can do it via memory. And so it's super interesting, and I was just learning about Alabama, so I noticed that they had turnip greens. They like to eat that. So perhaps we can get that from North Carolina going to Alabama. Who knows? But that's why I brought that reference up. So the point is, if you're doing business as a business, interstate commerce, then the federal Constitution will apply to you. It happened at a country club that my parents were nice enough to allow me to be a member of when I was growing up and learn how to play golf there. And they wouldn't let women be members. And so when the man got divorced from the wife, then the wife said, I want the country club membership. And the country club said, man, you can't. We don't accept women.
You can have it. You just can't come in.
And so she said, that's not going to play. And she basically made an argument that you are not a private club because you have tournaments on Mondays. And you have people outside the club coming in. You're selling them T-shirts, you're selling them shirts, you're selling them golf balls. You're engaged in interstate commerce, and therefore you're not truly a private club, and therefore the federal Constitution applies, and you cannot discriminate against me being a non-private entity involved in interstate commerce as a woman, and I want to be a member, and she won, and she got the membership.
Well, that's kind of weird because, golf is an acronym.
I'm not sure I want to go there, but...
No, that's gentlemen only, ladies forbidden.
Yes, so it's amazing you're still married and happily married, Ed. I mean, I like poetry, and I've got ex-wives, so poetry doesn't work.
I told you many times to lay off the poetry if you want to keep a woman. No.
So in this particular case, the guy talks about the full extent of the law. So the bottom line is, hey, if one of my employees decides that they want to become a member of the KKK, man, they're free to do that. But they're not going to be employed by me, right?
Okay.
So I'd say, first of all, leave your pointy hat at the door, and thanks for coming. We'll send you your check. So the point is that they are free under the First Amendment to be racist, but not in my office, right? So the idea is that this guy's free to be a misogynist, have stereotypical conclusions about women, which the First Amendment protects, but in the environment he's violating, according to the president of Google, chairman, says their code of conduct. And then the only issue he's got is perhaps whether or not under the NLRB, which federal law would apply because they're engaged in interstate commerce, whether or not he's protected in talking about work environment issues and whether or not this memo falls under that. I don't think it does, but he can color that for sure.
What I did find was kind of interesting. The guy that wrote this article, or the memo, actually, James Stanmore, the gentleman that was fired.
Yeah, the man who will never get a date in California.
Yeah. He said he wanted an openness of discussion, an openness of,
He's going to have to go to farmersonly.com and
but
because that's weird. The only place they're going to...
He says he's fired because there was an intolerance for ideologies that don't fit what he believed were the company's left-leaning biases. And I'm going, I didn't realize... having arguments about the suppression of women would constitute a left-leaning bias.
Hey, I don't know.
It's kind of so the guy's not only a crackpot and going outside of the work environment and bringing up stuff that is completely improper.
Yeah, I mean, there's Rosa Parks, people that you can really get behind in terms of changing the dynamic of how we interact with race and gender. Then you got this guy who thinks he's got the flag of freedom flying in front of him, and actually he's just carrying a weight of stupidity behind him, and it's going to lead him down into the depths of despair because he's toast to Google. You can say goodbye to any other company, Apple. You know who offered him a job?
No.
Julian Assange from WikiLeaks said, "We celebrate free discourse. Come join me at the Ecuadorian embassy in England, in London." So he did get that job offer.
Good luck with that.
Yeah, I know. It's like, oh gosh. I mean, right on, Julian Assange. Way to celebrate a guy who's has a stereotypical misogynistic kind of, attitudes towards women, and let's celebrate this guy.
You know,
We can celebrate free speech, but you don't have to celebrate the message. The message is idiotic.
Well, here it is. It's almost a self-fulfilling prophecy. He's saying that women are not getting these jobs for all these reasons, and those are reasons that he holds in his head, and it's his own biases in that regard that are ingrained in his own ideologies that are preventing women that he would hire.
Well, he had
that
these
are absolutely qualified.
He had all these perceived barriers of his employment advancement. And now he doesn't have to have any perceived barriers. He's got a real one, which is he's got this memo. He's toast. So he's going to have to. You're going to have to move to another state.
He'd be better off going to the bank, Swedish banking.
Yeah, they speak Spanish in Ecuador, so brush up on your Spanish because the Ecuadorian apparently the embassy is pretty nice, and
Really?
and apparently Julian Assange has got his own treadmill that he has on his balcony, so you can work out with him as well. So we're about ready to take a break, and then we'll come back and we'll talk about that case is colorable under the NLRB. We'll talk about a Swedish banker who actually was head of the finance committee, I think, in Sweden, and then worked for Citibank. Got a little bit too drunk at a party and decided to expose his genitalia in a contest of size, and that ultimately led to his demise and his departure from Citibank. And we'll talk about how that's an easy choice of breach of contract within the confines of labor law. I'm joined by Ed Shady, Craig Ashton, all things legal. Stay with us. All right, this is Craig Ashton. I think G is bringing us into this segment with a short people song. Perhaps to segue into this crazy Swedish investment banker with Citibank. His name is Anders Borg.
The Borg.
And he basically showed you exactly how you're going to have no colorable argument and that you're going to be in violation of your employment contract and you're going to get fired. I'm joined by Edward Shady, a Shady attorney, giving you some legal advice, which in this particular case is the most valuable advice you're ever going to get from a Shady attorney in your existence, and I can say that without equivocation. All right, so we were talking about the guy at Google, colorable. He said, I have a right to express my concerns about the terms and conditions of my working environment and to bring up potentially illegal behavior, which is what my document does, referring to women have anxiety, they're not well suited for engineering, et cetera, all these stereotypes. He's clearly referencing broad language, which would tie in the NLRB Section 7, which allows that kind of discussion, trying to set himself up for a federal violation of his statutory rights. I don't know how that's going to shake out. I think he's going to lose, but we'll see. Clearly, he'll never get a date, and he's not going to work in the Silicon Valley ever again. That, I think, is a fact. Then we got Anders Borg, right?
He won't work in the Silicon Valley, and his next date's going to be made in silicone.
Yeah, right, exactly. Yeah. So he's got a kind of an ally in this Anders Borg. I mean, at least Anders Borg was drunk, right? There's a great line from Winston Churchill. He was at a party, and a lady said to him, "Sir, you are drunk." And he says, "Yes, I am drunk, but you are ugly, and tomorrow I'll be sober." So Anders Borg, at least this guy is blackout drunk at a party.
House party.
At a house party. And so he decided to start comparing his exposed manhood to other guests, according to the article. And then he started calling the female guests whores and sluts. So, hey, blackout drunk, not blackout drunk. Yeah, right.
Well, it was a house party outside of Stockholm, so I don't know how long he was there at the party, and if Stockholm syndrome set in, and everybody else was behaving this way, and he had to conform to his captors. Well, but he's got problems with possible sexual assault. If it was here in the States.
So he's criminal in Sweden, right?
Yeah.
And as a matter of fact, it's funny that Julian Assange has actually got charges of rape in Sweden as well, and that's one of the reasons he's staying in the Ecuadorian embassy, because he doesn't want to be extradited to Sweden.
Yeah, I mean, you've got you're coming at you with your manhood. There's assault there for the apprehension of an awful touching, and if he did touch it, it's battery and emotional distress associated with this guy coming around drunk, waving his manhood at everybody. And saying, "Hey, do you measure up? Do you want to raise?"
Yeah. So yeah, Jackass is looking for a new character. So he was vice chairman of the board of directors of Connectfix, which is a company in Sweden, and he was also high up with Citibank. Citigroup. And he was Sweden's Minister of Finance from 2006 to 2014 and took him through the financial crisis. So the guy's got some gravitas. He's got a drinking problem. So the good news for him is he gets rid of the alcohol, gets rid of the problem. I guarantee you the guy's not on a normal day going to show up to work and by 8:30 is challenging everybody in the office, to determine who's more well endowed. So this guy's out of a job. His name is Borg. Dan Moore's out of a job. They both seem to have misogynistic references to women, so they can start their own consulting company called Dan Moore and Borg.
There you go.
And now they solve that problem, and then they can start their own business, and they can act as they like, because they will have morality clauses that are much broader than the rest of the public.
There is
and
no morality clause.
Exactly. Because you can enter into a contract to say, look, here's the way my contract's going to read. Morality is subjective. It's too subjectively defined, and we cannot define that between you and I in any way. So the only way that I get fired is if I get convicted of a felony. Short of that, I am hired for life. You cannot fire me for cause. You can't hire me for what you believe is a morality violation, because I don't believe we can define that, because we may have differences of opinion in regards to what is appropriate behavior within the confines of morality. And you could have a contract which say you can only fire me for cause if I'm convicted of a felony. At that point, this dude would still have a job.
Yeah, no kidding. Most people would still have a job.
Exactly. But, some people are that valuable. I mean, you might say, all right, you are so valuable that I will agree to that. And as long as you negotiate those terms, it's not in violation of public policy. That would be enforceable.
If it's a publicly traded company, I don't think the board of directors and especially the stockholders would be appreciative of that. But most large companies...
Well, let's say the Queen of England decides that she's going to endorse Pepsi. And she says, I like to drink vodka in the morning. I drink champagne in the afternoon. I don't want any morality clauses. So the only way you can get rid of me, Queen of England, is if I commit a felony. I bet you they would agree to that.
No, because she's a staunch Pepsi drinker or Coca-Cola drinker. But no, most people that have ever worked in the corporate world know that when every year you have to go through the corporate handbook, the employee handbook it's called, and there's a signature line in the back. You sign it, turn it in. And when you screw up, they bring it out and said, you agreed and we're on notice, and you signed off that you were aware of all of these issues. And that's what they usually use for purposes of termination when you screw up as bad as this guy did.
So general rule is you're employee at will in California. Even if you have a contract, there's going to be a morality clause, usually a code of conduct clause. That's what Google's enforcing. That's what the investment banker in Sweden is facing. It was on a private party, but it got out into the public, and all of a sudden that calls into question his judgment, and they had to get rid of him. He quit, right? So the point is that, the banker is an obvious example of what you should not do in any setting. The Google issue is colorable in regards to federal National Labor Relations Board law. First Amendment does not protect your right to spout off anything that you want to say in work, and your employer can fire you for whatever reason, as long as it's not gender, race, sexual orientation, age, etc. Those would be illegal, but everything else is fair game. So be careful. Just because the First Amendment protects the government from stopping you from saying anything doesn't mean that Intel can't. So that's what you need to pay attention to. Let's transition to a couple breach of contract cases. So this couple in San Francisco noticed that there was $14 that was in arrears on a private cul-de-sac in the Presidio. There's 181 private streets in San Francisco, and one of them is Presidio Terrace. And basically, I think the last property that was sold there was $16 million. Dianne
Feinstein lived in that neighborhood.
Yeah, Dianne Feinstein lived there while she, I think, was running for governor way back. So the moral of the story is that this is a private street, and apparently the city of San Francisco was sending them tax notices to an address that they provided, which hasn't been accurate for a while.
It was a yoga studio.
It was a yoga studio. But the problem is that it's incumbent upon the taxpayer to know and make sure that they have the right address. Because if you're not getting a tax bill for 20 years, then you're probably missing something.
That's what this said. It said somehow payment for the $14 a year property tax on the street was overlooked for decades.
So this couple, not married but just business partners, looks like, they saw this and they went to a tax lien sale and they bought the private property for $90,000. Bought the private street. So now they're thinking about putting in meters and charging rent to park on the street, right?
I'll put a toll gate in.
So the homeowners must. So okay, is everybody sitting down? I just have to let you know it's. I would say non-caffeinated drinks this morning because I have some bad news. That house that you paid $16 million for? You're gonna have to pay a toll to get in the gate. Billy Goat Gruff, and basically it's going to be very expensive for you. So that's going to be whether or not this particular transaction was unconscionable, and whether or not it's not enforceable, and whether or not they would be able to get out of this. The homeowners association would be able to get out of this based upon lack of notice.
I don't think the homeowners association is going to be able to be able to get out of this. The problem is really going to be, normally in a group like this, you hire a consulting firm, and they do the association's bidding. They take care of all the impound accounts. They take care of the street maintenance. They take care of everything. So whoever the maintenance company was or the property management company for the homeowners association is really looking at a lawsuit for their malfeasance and not catching
Yeah, it's going to be interesting to see because this is a straight-up notice, tax lien contract sale. And it doesn't. And the only issue would be whether or not it's unconscionable to not give them notice and allow them to at least get their street back. I mean, it's simply not. The way this is shaken out is not fair for sure.
I don't know why. Because when you do a tax lien sale, it's actually posted in the newspaper, which nobody reads unless you're looking for that. These guys happened to probably see it in the paper, took advantage of it, went down for the bidding. So everybody that lived on the street had an opportunity to be put on notice when it was published. Because even when we can't find a defendant here in the state of California, we can do what's called service by publication, and the courts deem that to be reasonable.
Yeah, proper notice, right?
So in this instance, they were put on notice, and they just missed it.
Yeah, so bottom line is nobody's going to break out the violins for all these multimillionaires who screwed up and didn't pay for their streets. So we'll see. We'll keep you apprised of what's going on. We didn't get to fiance stole my dog and the contract issues and what you do with an engagement ring. We'll talk about that tomorrow. We'll talk about cyber criminals are going after grandpa's pacemaker. And we'll talk about Taylor Swift and grab of the buttocks and whether or not that's assault and battery within the confines of defamation case. We'll do that tomorrow. This is All Things Legal. Thanks for joining us.
You've been listening to the All Things Legal Show with your host, Craig Ashton. For more information or to download the latest podcast, go to ashtonandprice.com or call 916-786-7787. Remember, for the best advice, don't think twice. Call Ashton and Price.